do you need to disclose a close friendship that triggers potential consequences? It's a given that you don't have to make a disclosure that we're both members of the Chartered Institute of Arbitrators. It's a given. And in my career as an arbitrator, I have never had occasion to make a disclosure of a connection to a co-arbitrator. But as I say, situations have arisen which have caused me to wonder whether there are circumstances when I should make such a disclosure. And that situation typically is when I'm appointed as a chair, and often it's the other two arbitrators that make the appointment, and I have some connection to one of those two, am I able to disclose that connection? So how the situation has come up for me is that friends have said to me, hey, I'd like to appoint you as the chair. Are you available? And in a couple of cases, I've said, well, I'm available. I'm just not sure we should be on the same tribunal. It just doesn't feel right. And if we are on the tribunal, just to what extent must we disclose the close friendship that we have? And so, just to give you maybe a concrete example of where the tension might exist, consider John Beachy, who is the chairman of the board of the center, calls me and says, will you be available to sit as the chair? He's the chairman of a board of directors. I'm on the board of directors. Quite frankly, I don't see any reason why I would have to make any disclosure. What's the conflict? Why would anybody care? Now consider Shan asking me if I would be available to be a chair. Well, the situation is different. Shan answers to the board of directors. There's a reason there that somebody might be concerned that she might not want to disagree with me if I have a power of decision over something that affects her life. So given that kind of potential conflict, I just embarked upon my own inquiries, which have led to the paper that we're talking about today. And I started to look at the sources of law, and as arbitrators, we know that if you have an issue, the first task is to say, okay, what are the sources of law which may assist in resolving that issue? And there can be many sources of law. There can be case law, there can be legislation, there can be international conventions, and then there's common sense. And so I started to ask friends and colleagues what they thought, and so I also have the sort of anecdotal suggestions as to how to resolve this problem. Typically, the first answer is, and I'm sure Mark will say this, well, just disclose everything. What's the problem? And we all know that the solution to a conflict is disclosure. Make the disclosure, no problem. So that's the first immediate response of everyone. The second response on this particular topic is, what's the problem? Judges on courts of appeal are close friends, and nobody's ever made a complaint about that. Why would it be different for arbitration? And of course, and I'll come back to this later, because I think that attitude might actually influence the judges who make the decisions on these points when it comes to a challenge in the courts. I think that the quick answer is you don't get to choose your judge in the Court of Appeal, but you do get to choose your arbitrators. And if Shan is appointed by one party and Mark is appointed by another party, and I become the chair and no disclosure is made, would the party that appointed Mark think, wait a minute, there's going to be an alignment between the chair and the other party's appointee. Now, I know that every appointee, party appointed appointee is supposed to be impartial. But having said that, the parties might be concerned to know that there is some potential connection which might influence the thinking. And so coming back to the premises that I was discussing earlier about, where do I find the answer to this question and the sources of law? I think that we have to look at what courts of appeal have ruled, what codes of ethics have to say about it, and so that's why I've done the canvas, which is contained here. Clearly, there can be a myriad of connections. It's an unlimited source of potential connections between, the co-arbitrator is a former law partner. The co-arbitrator is my best friend. The co-arbitrator is my father-in-law. I mean, it's endless of what's possible, but what's impermissible is the bottom line. And I should say up front that in my canvas, what I've discovered is that there is not a single case in which an award has been set aside because of a failure of co-arbitrators to make disclosure of possible connections. Doesn't mean that there won't be, and there actually is one case that I'll mention to you where it was set aside, an award was set aside because of a connection between co-arbitrators, but the Court of Appeal then set aside that decision. So there is, to my knowledge, no case ever decided that has caused the award to be set aside. Now, I'm not sure I'll get to everything, but just again to set the stage for the discussion which will follow, I'll jump right to the end and say this. How horrible would it be if we had an award set aside because we didn't make the disclosure? It's like, oh, it's the worst thing you can possibly imagine. Worse than that, though, is there may be potential liability if you do not make that disclosure. And so there is good reason to take this seriously, notwithstanding the absence of any actual case where it's been set aside. And so coming back again to my starting point, which is, okay, sources of law. And the first thing you do when you look for the source of law is, what's the issue? Well, on what metric do we decide this issue? And so I think everyone would say, okay, well, it comes from the requirement that you be impartial and that you be independent. And virtually every jurisdiction, whether in statute or in the rules of the institution that is involved in administering the arbitration, there will be a provision that says that you are obliged to make disclosure of any circumstance that might give rise to justifiable concerns as to independence or impartiality. Okay, so is that the test that we're using, independence and impartiality? Because does a co-arbitrator conflict really fit into the rubric of that discussion? Is there something about impartiality or predisposition on to decide the issue in a certain way, or connection to a party? There's no party connection here. It's a connection between arbitrators. There's no direct line to a party. And yet, as a party, I really do want to know if the chair and the other party's nominee have a connection. And so, in thinking it through in my own head, I'm trying to think, well, I know in my gut that there is going to be a circumstance that does oblige me to make that disclosure, but why? What is driving that concern, and what exposes me to having my award set aside, or what exposes me to potential civil liability? And so I wonder, sometimes whether an aspect of fiduciary duty is that, so again, we're going back to basic principles. My thesis is that the relationship between the arbitrators and the parties is one of contract. It's a tripartite contract, and the parties are the parties to the contract are the two parties to the dispute, and the arbitrator, or in some cases the tribunal. And as an aspect of that, you then derive the principles of what is. It's not, so fiduciaries aren't contractual parties. It's a question of status, but I think that there is embedded in that rubric of a contractual relationship between the arbitrators and the parties an element of fiduciary obligation to make disclosure of what is objectively, common sense, reasonably a fact that should be disclosed. So that is an analytical format. Then we go on to say, okay, well, where do we find some assistance in getting the answers to the question of what must and should be disclosed? As I say, to my knowledge, there is no set of rules or Arbitration Act provision that says co-arbitrators must do anything. It's that one thing. It's just any circumstance that might give rise to justifiable concerns about independence or impartiality. But there are some sources of law that can be of assistance in if you were a judge deciding the question, beginning with international conventions, which are not law per se. They are what I'll call soft law, but codes of ethics, matters. Well, we all know that the IBA rules on conflicts. These are not binding. Well, they can be binding if the parties agree that they should be binding, but typically they're not binding. They're just something that a court might look at to demonstrate the general principles that are accepted in the arbitral community. So let's go right straight to the first one, which is the IBA rules. We all know about the orange, the green, the red list, and just to jump to the main point, there is a provision in the orange list which suggests that disclosure ought to be made if an arbitrator has acted as co-counsel with another arbitrator within the previous 3 years, and co-arbitrators must disclose if they are currently members of the same law firm or barristers' chambers. That's it. You'd think the IBA rules of any place would wrestle this one to the ground, but there is nothing in the IBA rules about close personal friendships, which is somewhat surprising. But I think that maybe this is an evolving area that is coming to the fore now, and because we do see some instances where it is dealt with. So the next source of soft law is the College of Commercial Arbitrators Guide to Best Practices in Commercial Arbitration. And that set of guidelines provides that any ongoing or recent business or professional relationship between the proposed arbitrator and a party, counsel, a known witness, or a co-arbitrator should be disclosed. So there has been some recognition that there's an underlying duty there to disclose something. We don't know exactly what. And then we come to the American Arbitration Association Code of Ethics. And this one is more specific. It does call for disclosure of personal relationships. And in terms, it says that any known or indirect financial or personal interest in the outcome of the arbitration, any known, existing, or past financial, business, or professional or personal relationships which might reasonably affect impartiality or lack of independence in the eyes of the parties. For example, prospective arbitrators should disclose any such relationships which they personally have with any party, its lawyer, or any co-arbitrator. Okay, so now that AAA nails it on the head. This is interesting because this is starting to explain to me, uh, when I've done my canvas of friends and colleagues, why there are different approaches in different places. Um, when I talk to my friends in Canada, they basically say, well, there's no problem. You just don't need to make that kind of a disclosure. When I talk to my friends in Houston, what a difference. The American practice, tradition, culture is such that extensive disclosures are thought to be made, or that should be made. And so in England, I mean, members of chambers historically could sit as co-arbitrators and as chair, and it was not frowned upon. Recently, I think there's been some criticism of that, and there has been a movement in England. But nevertheless, my thesis is that it's those background sources of law that influence the culture in the places that allow the Canadians to be a little more cavalier, Americans to be a little more concerned, and Europeans to be less concerned. And the AAA rules reflect a perfect example of that. Okay, then most recently, this has come up in the July 2023 UNCITRAL draft code of conduct for arbitrators in investment disputes. This is it's pretty near to being the final product. It's still in draft form, but the Article 11 of the draft code does require disclosure by an arbitrator of any financial, business, professional, or close personal relationship in the past 5 years with a co-arbitrator. So now we are seeing a greater level of what I'll call sophistication on this issue of everyone in the arbitration, international arbitration community knows that UNCITRAL has input from everybody who's anybody. And so this then is starting to, I think, reflect a more modern approach that says, yes, personal friendships are something that ought to be disclosed. I'm going to jump now from the soft law sources and look at the legislative and case law sources that also inform the culture of what people think should be disclosed in arbitrator conflicts. And just to summarize, it basically comes down to this: that in Commonwealth codings and the FAA and evident partiality and all of the things that we all know is the American position. The test, the bar, is basically if there's a possibility of bias. In Europe, likewise, the bar is very low. It's the possibility of bias that informs the obligation. Whereas in Canada and in England, and England's a bit complicated, and if I have time, I'll explain that. That it's not a possible danger of bias; it requires a real danger of bias. And so, whereas the U.S. right now is still in the possibility of bias being the test, I think there's potential that this is going to change, in particular because there are two cases that are now before the Supreme Court of the United States where conflicts are the main issue. And I think I'm just going to jump to that so that we can have that available for our discussion. The two cases that involve that are now before the United States Supreme Court are Occidental Petroleum, our Occidental Exploration and Production Company, and Andes Petroleum is one, and the other is Grupo Unidos involving the Panama Canal. in both of the case that led up, or the precedent that will be considered in those cases, is a decision in the United States Court of Appeals for the Second Circuit, the Scandinavian reinsurance case. The question on appeal was whether the failure of arbitrators to disclose their concurrent services arbitrators in another arbitration with similar issues in a common witness constituted evident partiality within the meaning of the FAA. The United States District Court for the Southern District of New York, Shira Scheinlin presiding, ordered the award vacated on the basis that the two members of the panel failed to disclose they were serving in an overlapping arbitration proceeding. The Court of Appeals for the Second Circuit reversed the decision, saying the overlapping service did not suggest that the arbitrators were predisposed to rule in any particular way, and that their failure of disclosure was not indicative of evident partiality. And I just pause there to say that I think this just shows the difficulty of fitting this conundrum into the rubric of evident partiality or lack of independence. Scandinavian reinsurance was one of the precedent cases, and another one from the US from 2004, which deals with this subject, is Lucent Technologies and Tatung, and the citations are in the paper. And the court there noted, and this is what's significant, that there was no precedent case in which the Commonwealth Codings test had been applied to an undisclosed relationship between co-arbitrators. Again, my suspicion is that kind of attitude from courts of appeal is informed to some extent by their own cloistered existence, where they sit all the time with their best friends, because judges are cloistered and most of their friends are other judges, and so they would think that way. But in any event, we come to the two cases which are now before the U.S. Supreme Court. In Occidental Exploration, the U.S. Court of Appeals for the Second Circuit upheld an ICD arbitral award in favor of Andes for $392 million. One of the tribunal members, Robert Smith, failed to disclose that he was co-arbitrator with Lawrence Shaw, counsel for Andes, in a separate, unrelated arbitration. The Second Circuit held that Occidental did not provide evidence that Smith was partial and did not allege a material relationship, such as a family connection or an ongoing business arrangement with the party or its firm, which would be a circumstance which would cause a reasonable person to infer a connection between the undisclosed outside relationship and a possibility of bias. In another case, the other case, the Grupo Unidas, the Panama Canal case, the 11th Circuit considered a case in which co-arbitrators were, again, concurrently serving on other tribunals. There, the award was $285 million in favor of Autoridad. And in that case, what happened was that Autoridad nominated Robert Gateskill to be the party-nominated arbitrator. Grupo Unidos nominated Klaus von Wobesser. I'll just pause here to say that when these arbitrators made the disclosures of what cases they were involved in, as a result of the challenge, they made extensive further disclosures. These gentlemen were serving on dozens of ongoing arbitrations. I mean, for me, if I have 6 a year, I'm busy. How they deal with dozens, and these are usually investor state cases that they're on. It just blows my mind. But anyway, I digress. The parties agreed on Pierre-Yves Gunter as president of the tribunal. After the award was issued, Grupo Unidos discovered that Gateskill subsequently appointed Gunter as chair in a concurrent arbitration. So what you have is now not purchasing favoritism, but establishing a meaningful connection with the co-arbitrator, which might objectively, reasonably be thought to be something that might influence them to think alike, to be less disagreeable with each other. And again, for a party, that's a legitimate concern. In any event, the 11th Circuit ruled that any danger that Gateskill purchased Gunter's concurrence was speculative and unreasonable. And so there you have it. There are two cases now before the Supreme Court of the United States that will potentially test the evident partiality rule from Commonwealth codings and possibly raise the bar. Now, I'm out of time, so I'll just say that what's happened internationally is that my jurisdiction, British Columbia, England, in a case called Goff, Australia, have established what's called the Goff test, which is a real danger test as opposed to a possibility of bias test. The question that arises is whether or not the Supreme Court of the United States might now move to that more international, modern, nuanced test of that requires a real danger of bias rather than a mere possibility of bias, and that could change the complexion of conflicts laws dramatically. And so I'm going to end there and leave it to Whit after lunch to get your thoughts on a lot of these issues. So thank you very much.
Thank you very much, Murray. And I think that gives us some topics for discussion over the lunch break. We will be heading to the moorings for lunch. They're at the restaurant there. As soon as you enter the moorings, it's on your right. You just follow the trail. The staff will escort you down, and then we'll be returning at 2:30, where we will have Whit will guide everyone to get your opinions and views on your experience with this issue and how we deal with it. So please feel free to enjoy lunch. Thank you.